Welcome everyone to the ongoing and continuing Baylor webinar sponsored by the Baylor Law Executive LLM and Litigation Management. I appreciate everyone joining us today for what ought to be an interesting discussion with a good friend of mine and a supporter of our program, Jeff Carr. Today we're going to be talking about the management of the cost of litigation from an in-house counsel perspective. For those of you that don't know, our program has a framework for managing litigation to achieve effectiveness and efficiency, and that framework includes a bunch of different pillars: doing things the right way with the right plan at the right cost, to using the right tools with the right team to achieve the right result. And today's focus will be, from an in-house perspective, the right cost for managing litigation. And there's nobody better to talk about this topic than the legal rebel that he is, Jeff Carr. I've read a number of different things about Jeff recently, about his, I guess, second retirement from the in-house counsel position. He was with FMC Technologies, most recently with Univar Solutions, and he has been a speaker on this topic, a rebel in this area, in a good way for many, many years. And I've heard him speak a number of times. So I'm going to turn it largely over to Jeff. I'll be monitoring the chat feature. And if anybody has any questions, go ahead and put them into the chat, and we'll try to get an answer to the question from Jeff. Today, Jeff's going to be talking about what he calls plan, perform, and perfect, or the 3 Ps, or P to the third, and in terms of managing litigation from an in-house counsel perspective, cost effectively. Jeff, thank you for being with us, and I'm going to turn it over to you so you can have the screen and share your thoughts. And I also should say, Jeff is on a cellular device today because his high-speed internet is down, and we're going to try to do it as best we can under that set of circumstances. So Jeff, go ahead, talk to us about plan, perform, and perfect.
Well, thank you, Kyle. It is so great to be here. I hope you guys can all see me well enough. So I'm actually it's R3 cubed now. This is my third retirement. And I was riffed just recently from the company that I've been working with for the last 90 days. I had taken a position as their continuous improvement evangelist, and due to cost-cutting measures at the company, they decided to eliminate that program, which was fine, because what I really wanted was, I'm an old guy, so I'm eligible for Medicare, but my wife, who's a little bit younger than I am, is not. So what I really need is COBRA coverage more than anything else. And so, that's been secured through this third retirement. So it gives me time to race cars and drive boats, and then lob the occasional hand grenade into law land, which is what I do quite a bit. And it's great to be here with you guys today. I hope you have some great questions. I spent a long time in-house. I went in-house in 1993. And so when often I talk, I start out by saying things like, I'm not a lawyer. I'm a business person. I'm a lifeguard. I'm a mechanic. And, a lot of different things, but I'm not a lawyer. But of course I am. I am a lawyer. I was trained as a lawyer, practiced law in big law for a while, but most of my career has been spent in-house. And I became a general counsel in 2001, a job that I was wholly unqualified for at the time, and kind of grew into. And that was with FMC Technologies. And I went from being the youngest member of the management team with the fewest years of service with that team to being, when I retired the first time in 2014, to being the only member of the management team, the executive team, that was left from that original group. I'd been through 3 CEOs, and so I had become, I was the old gray-haired guy at that point, and it was time for me to leave FMC. I retired. I then answered the phone inappropriately one day and some guy talked me into taking a job at Univar Solutions as their general counsel to try to rebuild their legal department, which I did for a few years. I left them a few years ago, and then I went into Elevate, a legal service provider, in this continuous improvement role. So like I said, I'm in R3 status again, but I truly, I talk a lot about the profession, and I worry about the profession, and I worry that it's lost its way. I want to try to give you all a perspective of somebody who's been in the trenches for a long time, but has been in the trenches in a company as a customer. And the weird job about being in-house is that you are both a customer and a supplier. Your job is to be a lawyer for the company, but you're also arranging for legal services throughout. So you're a customer from the legal service supply chain, whether that's law firm, alternative legal service providers, consultants, affiliated professionals, whoever they are. A lot of the job of a general counsel is, well, you have three jobs. One is to be the consigliere to the board and the senior management, and to be a member of the executive team. The second job is to build and run a high performance legal team. And the third job is to help the company achieve its objectives. So you're the head of the function, and that's actually the only time you're really being a lawyer, when you're providing that counseling to people. Most of the time, you're a manager or a leader. And most of that has to do with managing money more than anything else. So let's talk about disputes. That's what we're here to talk about today. That is a big job, as I'm sure you realize, as part of the in-house function. You spend an awful lot of your time dealing with litigation, dealing with disputes, dealing with the financial aspects of that. Let me just ground you quickly about this. There is not a company on the face of the earth that wants disputes or litigation. Let me back up a little bit. If you're a law firm, you're a company that actually likes to have litigation because it gives you something to do and something to bill for. If you are a patent troll and you make your money by bringing patent cases, you'll want litigation. But by and large, companies are not there to answer interesting questions of law, nor do they want disputes. Disputes are a fact of life and business, and we have to deal with them. So that leads us to what I'm going to talk about today are three things. I'm going to talk about P3 in a minute, but what I'm really going to talk about let's talk about philosophy and approach first. Then I want to talk about P3, which is how do you deal with things. And then I want to talk about do a quick hot wash. So one of the things you're going to learn today is a quick tool that you can use. And thank you very much for putting the presentation up here. So let's talk about the philosophy and approach. As I said, companies don't want disputes. They certainly don't want litigation. Litigation is expensive, and it takes you away from what your core purpose is, which is to provide services and products to your customers. But they're a fact of life, and they have to be dealt with. So that takes us to what I call the virtuous circle, which is your real approach when it comes to disputes is first to avoid them. Second, it's to manage them and resolve them. And the third is then to learn from them. The reason you want to learn from them, that's the virtuous circle part, is so that then you can avoid them in the future. The next thing I want to talk a little bit about are the divergent interests of our legal service supply chain and lawyers themselves. In-house lawyers are no different than outside lawyers. We all suffer from a hero complex. We all love to ride in on the horse and save the day. That's one of the reasons we all like litigation, frankly, because you can run in, you save the day, and then you go on to the next dispute. Well, but you have to keep in mind that your customer really did not want that dispute. It's just something that they're involved in now, and they now need to get rid of it. So you got to understand that the divergence of the interest of the legal service provider, whether in-house or outside, differs somewhat from the customer. And you'll notice that I always use the word customer. I don't use the word client. And I do that consciously. And I encourage you to think that way. Because once you start thinking of the people that you are billing as customers and not clients, you start putting yourself in that position. Is what I am about to do and is what I'm about to bill for, is it useful? Is it necessary? Does it further the customer's interest? Does it help them satisfy their objectives? And that's one of the things that you need to think about. So the interest of the legal service provider, quite frankly, diverges from the interest of the company. The place that they converge is in resolution. How do you resolve the issue? However, if you're a defense firm, your interest generally, and this is not, I don't mean to be pernicious about it, but your interests are generally in prolonging the matter. And it's subconscious, it's not conscious, but many a billable hour has been spent in the name of the zealous representation of the client. If you're a plaintiff's firm, you actually want to do as little work as possible and get the most money that you can, assuming you're on a contingent fee basis, which many people are. So the monkey in the middle here is the customer. Whether you have engaged counsel as plaintiff's counsel or as defense counsel, you got to understand that there is an interest in that part of the relationship shifting value to their side of the table as opposed to your side of the table. One of the jobs that you do as an in-house counsel is you have to look at every dispute holistically. And you look at the dispute from the standpoint of, I really want to resolve this. I'm here. I have been unsuccessful in avoiding the dispute. My business has been unsuccessful in avoiding the dispute. So we're here. Now we need to resolve it. Most of the time, and this is where I think in-house counsel and outside providers often differ, is for almost every type of dispute that you have as a company, it's just an economic transaction. And your job as the in-house counsel or the in-house manager is to manage the money flow out of your company to as low a number as possible in getting to resolution. So let me put that a little more simply. I can pay $1 to a plaintiff or $1 to a defense counsel. It's still $1 to the company. And my job is to keep the dollars going out the door as low as possible. Now, where does that become wrong? And it becomes wrong when you are in incredibly important litigation, something that threatens the existence of your company, either existentially, or if it threatens to unleash a tsunami of disputes that could bury your company. So you have to kind of look at every dispute from what is the nature of the dispute. Is it simply a commercial dispute? Is it simply an injury dispute? Now, and when I say simply, I don't mean to characterize it as unimportant. Of course it's important. Of course the people that are involved are interested in it. But from the company's standpoint, what you really want is resolution. It's no more or less important than any other one. And it's just a question of how do you get to that resolution point. Some, as I say, are incredibly important. Now, Kyle will tell you, and I will tell you, and the statistics will tell you, that 95% of all disputes, once they've gone into litigation, get resolved before going to the final finder of fact, whether that's an arbitrator, a judge, or a jury. 95%. I mean, think about that number. That's pretty amazing. And I can tell you from personal experience, having done it for about 20 years, 94.6% of our matters were resolved before going to the final finder of fact. So if you think about it that way, you think about it as how do I get to resolution quickest and least expensively? Because chances are I'm going to settle this case. So the critical part is identifying what cases do you really have to resolve. So that's the overall philosophy. The overall philosophy is saying that this is an economic transaction generally. So let's treat it as such and let's resolve it as such. So now let's talk about how does that work in the real world. I mean, first you have to you always start with why, okay? You always start with why are we here? What are we trying to achieve? What is the purpose? And so as I said, the why here is resolution. That's the real interest of the customer. So let's talk about the real world and what I call P3, which is plan, perform, perfect. Once you're in a dispute, it's just a project like any other project. And like any other project, you should approach it exactly the same way. And that's through a disciplined approach to plan, execute the plan, and then learn from the experience. That's the plan, perform, perfect. The absolutely most important part of this is the plan. And a plan has really three elements. And those elements are, first, what is the objective? And if your customer, if your client tells you, I want to win, I want to win, I want a verdict for the defense, or I want a verdict for the plaintiff, I want to put the other side out of business, whatever that may be. Well, I like to tell my business people that, because often they say, we're going to defend this to the end. It's a matter of principle. Okay? We have been wronged. It is a matter of principle. Our honor is at stake. And I often would tell my business people, if you want to litigate on principle, get ready to pay a lot in interest, because that's kind of what's going to go on here. So instead, you have to say, what is your real objective? Is it to win? Is it to keep the number of dollars out the door to as low a point as possible? Is it to preserve, if you're in litigation or a dispute with a customer or a supplier, is it to preserve the business relationship? Is that what's more important? Is it to send a message to your workforce that simply filing a claim doesn't mean you get a check? Is it a mass tort case where you say, you don't file a claim, you get a check, you actually have to earn your money somehow by showing manifestation of injury and some responsibility or causation? Is it to cut off a competitor's access to something else? Is it to protect your intellectual property? So, what is your objective first from the customer? That requires communication between the customer and the provider. Once you understand what the objective is, then the provider can help you understand what are the resources that are going to be necessary in order to reach that objective. Because you can't really ask your outside provider to tell you how much it's going to cost and what your chances are unless you actually tell them and agree on what your objective is. So with the objective in place, then you move to the second stage, which is really, okay, who's going to do what when? It's just project management. What are the roles and responsibilities of each person on the litigation team? What are they going to do? When are they going to do it? How are they going to do it? And then the third element is the budget, price, if it's a fixed price matter. If you've given an objective that is a difficult objective to achieve, you should expect your provider to tell you it's going to cost you more money because there's more risk associated with it. So those are the three basic elements of a plan. Now,
Jeff, can I ask you this? I want to go this, and you mentioned something that's, I think, significant and important to me. When you use the term resource, we're talking largely in the legal profession. That's the resource of the people. And if you've got a high risk case, you need more people, and you've got to pay those people to do the work that you need for the high risk case. And you may need more people when it's a higher risk case. So it's up to, and if you understand the objective and you understand what resources are needed, then you can better assess the cost or the price that the firm can charge for that work.
Yeah, I agree with that, Kyle. I mean, I think that I use the word resource consciously because it is people, it can be tech.
Right.
And in the people aspect, it's a question of who and where. You may or may not need all attorneys on a matter. You may be able to offshore, in-source, outsource, various functions are in that. And that's what part of the plan is saying, okay, for each step in the process, what is the right tool? What is the right resource to be used to perform this particular step? May or may not be an attorney, may or may not be a person in a law firm. It might be somebody in-house, might be somebody at an alternative legal service provider. But you're right. The more complicated it is, the more difficult it is, the more resources it's going to consume and require. And that may be people, that may be and that may be tech, either one.
And I know you're I know your thoughts on this, but I want you to share them. And that is, if you're considering the resources and your client comes to you and your outside counsel, you got to think differently than, well, I just need to put 5 more associates on it. That may not be the correct solution to achieve the right cost for your client. It may be, but it may not be, because there's a variety of other resources that you can use to accomplish the same task as part of your plan that may be better suited to do so.
Absolutely
financially in particular, right?
That's absolutely right. And that's why most of this is really an exercise in dynamic communication. It's making, who's on the team, and part of the team includes the in-house people that are managing the matter, that are responsible for the matter. It also involves the ultimate customer, who is the business person in charge, the one throat to choke, if you will, who is accountable for this particular kind of matter. Is it somebody in ops? Is it somebody in finance? It's generally not somebody in the legal team. The legal team's a service provider. It's, who is responsible for the resolution of this matter, making sure that they're on board with the approach, the cost, the risk associated with it. And if you do that, if you have that dynamic communication, if things don't turn out the way you thought they were going to turn out, things go south on you, as long as everybody has been involved and there's been consultation throughout, you don't really have that difficult conversation about, you told me we were going to win and we didn't. That's because everybody's in this same boat together, as far as I'm concerned.
Got it.
Yeah. Oops, sorry about that. So let's then talk about, I think there's another slide in here that has some discussions in here about a particular dispute. So in the way I used to run things, part of the plan was we wanted an early case assessment very, very quickly in the matter, like within 90 days. And the early case assessment really was to help us decide whether or not we were going to continue to litigate this matter or not. And the early case assessment would, so one of the things that we're bad at as lawyers is the use of words. And you'd think we'd be better at this, but we're not. When the customer hears you as a lawyer say, what customer says, hey, what are our chances in this? What do you think? What's going to happen? And the lawyer looks at him and says, we have a good chance. Actually, they normally say, you have a good chance, instead of we. Say, you have a good chance. All right, well, the customer just heard 80% of success in using that phrase, when what you might have met was 20% chance of success. So we have a divergence just of pure communication there. Now, if you say more likely than not, okay, customer's going to understand that is probably around 51%, maybe a little bit north of that. If they say, this is a tough case, you might mean it's a 75% chance of success. Well, they're hearing it's a 10% chance of success. So it's one of the reasons that I always insisted upon the use of decision trees with our counsel. Partly because and it doesn't matter what kind of early case assessment tool you use, but you need to have some tool. The principle is matters cost money. They normally get worse over time. So the principle is we need to understand what the exposure or the recovery is now, as early as possible. So the behavior is we do that. We provide an early case assessment. The tool we used to use was a decision tree. You don't have to use decision trees. I just happen to like them. I think they're useful for a lot of reasons, because they're disciplined and because, frankly, your customers, your business people understand it. I have seen instances where you hand a senior VP a 40-page memo that he or she really can't get through. You hand them a 1-page decision tree that contained every bit of information that was in that 40-page memo. They understand it immediately. So it's just a useful tool, and it helps focus your mind as the service provider on what the risks are. So this is a decision tree And there are a few of them here. One, and it's just sitting there saying, okay, you know what, this was a commercial dispute, and what are the puts and takes. And in this particular case, there was a sense that there was a very good chance on resolving this matter. And so, you know, even though the claims were very, very high, it had a almost a $500,000 chance of or exposure here, which is a number over in the left side. The next two slides just go through different scenarios of what that liability is. So this one's neutral, $800,000 at risk. And the next one is that it's more pro customer, where you've got $1.1 million at risk. So what do you do as a counselor with that information? Well, at least with this information, you now can have the conversation, which is manifested on the next slide, which says, okay, you know, we've got different types of exposure. We've got, you know, a neutral case, a best case, a worst case. What are the costs associated with that? And then what are expenses associated with it? So you could sit there and say, okay, you know, our best case is that we're up $300,000, and our worst case is that we're down $4 million, depending upon what the probabilities are through that. In this particular case, the thought process was the best case was actually the best case. Had a very strong position on the facts and the law in this particular matter, but the exposure was significant, and it was a commercial reaction, or a commercial relationship. So the best option as the counselor was to say, you know, let's not litigate this thing. Let's resolve it now. Let's get let's see if we can do that by giving our customer a credit on future purchases. You know, and the conversation to the customer is sort of, we believe that we're going to prevail, you're going to lose, and we also believe that we're going to be awarded fees and expenses. We understand that you differ on that, and you may not believe that. But in order to go forward, it may well be best to try to resolve this now. We're going to give you a credit on future purchases. You know, pick a number, so, somewhere between, you know, the put and the take here. What that does is it preserves a customer relationship. If you use it as a discount as opposed to a flat credit, or say the credit has to be used in a particular amount of time, you're actually preserving the company's position as well. So commercially, that was, you know, it saved time, reduced money going out the door, it eliminated risk, and now the only risk here is that the customer leaves, goes someplace else. You lose those sales, and you lose that margin associated on it, but you're not out any other money, and that's probably the best approach. So that's that. Now, if your business people said, hell no, we're not doing that, not giving these guys credit, can't stand them, you know, you told me our case is a strong case, we want to litigate on this thing. Well, at least now, if things go south, and your exposure is now $4 million to the other company and expenses, at least you've had that conversation with your business people, and they bought into, and they understood what the risks were, what the puts and takes were. So that's where I think business counseling comes in the case, where you actually talk to your customer, you understand your customer, and you come to a position where you're in a better position to go forward. Hopefully that all makes sense.
Jeff, I was going to say, you know, at Bader, we talk a lot about decision trees as part of the planning of litigation and effective planning, and putting together the right team as well, and kind of assessing costs. Because if you do it and you do it well, you can see what the markers are potentially in litigation and where your resources are best spent, so that you don't waste time on things that won't really matter to the ultimate resolution that your client wants. And it can help you in the planning phase for putting together the plan to execute on the objectives that the client wants. And that's kind of what I hear you saying here.
Absolutely. And I think Kyle, you raised the perfect application of decision trees. It's, you know, at one level, it's kind of at that grand level of what's the client's ultimate objective and how do we get there. But the other, it helps you quite tactically too. You know, oftentimes you'll be faced with a situation where you can file a motion to dismiss, you can file a summary judgment motion, you could do whatever you might want to do. Well, the real question is, what is the marginal impact that's going to have on the case? What's the probability of success? If it's going to resolve the case and it has a high probability of success, it makes sense to invest in it. If it has a relatively low probability of success, you know, does it make sense at that instance? Do you file everything you can because you can, or do you only file those things that are going to materially contribute to success? I fall in the latter category. You know, let's keep the eye on the ball. What is the ultimate objective? And let's do stuff that that actually takes us in that direction. So I think that's absolutely right, Kyle. And I've always been amazed at how few people coming out of law schools, and I was one of them, you know, back in the Jurassic period when I graduated from law school, that, I mean, you know, never even heard of decision trees, have no idea how to use them, what they mean. I mean, I tell you, every one of your customers that's got an MBA knows how to use them, and those are a lot of the people that you're going to be talking with. So
somebody asked a question, and that was, how often did you use, Jeff, confidence intervals in the decision trees, and were they effective in communicating the probability and the magnitude of the risks associated with each option to your decision makers?
Absolutely. I mean, I think the use of confidence levels is kind of the truth teller, where you're sitting there and saying, you know, the probability here is 70-30 or whatever it may be. Giving people the confidence levels on that helps them to allocate, if you will, you know, what's the real risk on there. So, you know, I think those are all useful tools. The real question is, okay, how far do you want to go down the rabbit hole on some of these things? Because, excuse me, frankly, a lot of these things are predictive, you know, they may be based on data, but quite often are not. They may be based more on gut feel sometimes. That's okay. So, you know, your question is it's a good one on confidence levels, but there also can be a precision. You can have the more precise you get in your statistical analysis, the more certain it seems, where the underlying assumptions that went into it are still just assumptions. So, you know, so I think that's where confidence levels become very, very useful.
I know that, you know, Brad has got control of the screen right now, but I want to kind of go to something that I know you have on your screen. But when we talk about managing litigation from the in-house counsel perspective, it really relates to, in many respects, the relationship that you have with outside counsel. We talk about it in terms of cost, but I know many years ago, the Association of Corporate Counsel had this value challenge. And really what we're facing today is delivering. You know, I quite frankly don't care whether you're plaintiff or defense counsel. I think you have the obligation to deliver value to your client. And so that the cost of that litigation has to be commensurate with the value that's being delivered. I know you have some thoughts on that. And Brad, why don't you go to the slide that Jeff has so that I can help in this regard? The one that says, where do lawyers spend their time? And there's several on value. Okay. So why don't you comment on that in terms of managing the cost and the delivering of value, Jeff?
That's one of my favorite slides, Kyle. You know, and it's not just lawyers. I mean, it's every profession. There are lots of people that do lots of things that they think are incredibly important, and from the customer's perspective, don't really mean a whole heck of a lot to them. I think it's maybe the one just before.
One before it.
Yeah.
There you go.
Yeah. And you know, we do lots of stuff, and some of it does add value to the company, but you know, quite frankly, a lot of it doesn't. Now, so the question is, of all that stuff that's outside the value to the company side, how much of it is truly necessary versus how much of it is we like to do? And one of the things I used to say to people all the time is neither I nor my department are in the business of answering interesting questions of law. That's not what we do. We help the company achieve its business objectives. Sometimes, but rarely, those questions raise interesting questions of law. So we're not going to go down rabbit holes because we are interested in that particular issue. We're going to spend our time and we're going to spend our treasure on the things that matter to our customer, to the company. And so I think that's very, very important to do. Now, unfortunately, because most relationships with outside counsel, plaintiff relationships, as I said, generally are often contingent fee. But many relationships with outside counsel are fee for service. And fee for service is based more on activity these days than it is on results. The definition of a contingent fee is, by definition, it is a results-based engagement. So part of the question is, if you think about it from a customer's perspective, the customer wants results, not activity. They want outputs, not inputs. And yet, many times our billing models are based on inputs. And that's where I'm talking about you need to align those interests. The model that we used, and Carl, you put your finger right on it, it's a value-based model, and we call it delivered value. And because that's our job is to deliver value to our customer. And so here's a weird little secret for all y'all. You can tell I'm really Texan at heart because I use phrases like all y'all. The value is always, and I mean always, in the eye of the receiver. And we as providers often think, no, my time is what's valuable because that's all I have to sell. Actually, that's incorrect. What your customer actually wants to buy is not your time. They actually want your judgment, to the effect that that judgment helps them achieve their business objective. Let me diverge for a second and tell you a story, a personal story from the value side, and has to do with the medical industry. I had to have a knee replaced at one point, and I talked to a few different surgeons about it. One of them I asked, and I wanted to do a partial knee replacement as opposed to a full, if I could, because the conventional wisdom was, at my age, I was going to have it done again, and at least the current technology, you couldn't replace a full knee replacement again. So I wanted to have a partial, so at least I had some shot at outliving the joint. I went to one doctor, and the guy, and I asked him if he did partials or fulls. He said, well, it's irrelevant. You're not a candidate for a partial. And then I immediately fell into lawyer mode, saying, you didn't answer my question. My question was, do you do partials and fulls? And so we didn't use that surgeon. I went to another surgeon who he explained to me. He said, look, here's what happens. There are 3 providers of joints in the country. I like 2 of them. They each make a full and they each make a partial. I think we're going to use a partial from this manufacturer, but I frankly will not know until you are on that operating table and the surgery is being done. And the other little thing I need to tell you is, I don't do that much during the surgery. There's often a company tech in there and a machine that is doing most of the work. What I do is, as I open you up, I make the decision whether I'm going to use the partial or the full, and which company's partial or full I'm going to use. Application of my judgment at the time that judgment is important. And that's what I'm paying for. And that's exactly the same. Think about it from a lawyer's standpoint. Our highest and best use is our application of judgment to a particular situation, to a particular set of facts. It's not the activity that's associated with that. It's not the hours of time spent in the library or drafting a document or writing a brief. It is literally the judgment. For a trial lawyer, it's that judgment, and every trial lawyer's been there. Do I actually ask this question? That's literally what you're paying for, and that's literally what you want. How do I best tell the story to the jury to help my customer achieve their objectives here?
You know,
So that's
Jeff, I often call that when I'm teaching law students, I call that the Kenny Rogers rule. The judgment is you got to know when to hold them, know when to fold them, know when to walk away, know when to run, know when to play. You know, that's the Kenny Rogers rule. And that's what you're paying for. It's that value delivered to meet the objectives of the client.
That's right. And the good news is that's never going to be replaced by technology. It'll be augmented by technology. It'll be enabled by technology. But at the end of the day, when it really comes down to that situation where judgment matters, it's the application of that judgment. And that's the true value of our profession. And that's why I often say, everything lawyers do and everything the legal service industry does falls into 4 boxes. It's process, content, advocacy, and counseling. Counseling is actually the highest and best use because that's the part that has the highest value to the customer. And so I often say we need more counselors, fewer lawyers. But that's my belief. Now, when you need a gladiator, you need a gladiator. And so, as what I often also say is that litigation and disputes are always, and Kyle, correct me if you think I'm wrong on this, they are always a manifestation of human error, always. It's either in the design phase or in the operation phase, but it's always a human error. And therefore, every dispute can theoretically be prevented, every single one. Now, that's kind of like the objective in safety. Every injury can be prevented. The fact that they still occur doesn't mean that the principle of destination zero is impossible. It's just hard. It's just hard. So, and that's what we should strive for as customers. Okay, so let's see. So now we've gone through. We figured out the plan. We figured out the objective. We figured out the plan. The customer's all on board on how we're going to do this. So now let's talk to where the rubber really meets the road, and that's the fee engagement. Unless, Kyle, you want to go someplace else before I go.
No, I was going to say, go to how do you translate this delivering value in the real world where we're talking about people performing a service and expecting to get paid in some respect. And
exactly.
my thoughts about it. And I've always been a proponent that from a defense side of the docket, that you need to put some skin in the game. You need to be willing to quote risk maybe not be the right word, but I know that when you were doing this and you came up with some thoughts and ideas in that delivery of value that really puts, helps lawyer put their sort of practice where their promise is, I guess is the best way to say it.
Exactly. And so, and because I'm a lawyer and because we like to complexify things, the first system that we came up with back in, I think it was 1997, 1998, it was really complex. And over time, it's gotten simpler and simpler and more effective and more effective. But it comes down to, we talked a little bit about delivered value. And there should be a slide somewhere, and that's our job, is to deliver value. So, and people tell you all the time, well, you can't define that. It's like pornography. I know when I see it, but I can't tell you what it is. And I say that is nonsense. That is just absolute nonsense. Delivered value, so DV, delivered value, equals E3. It's a really simple, very simple math problem. What's E3? The first E is effectiveness. Was the customer's objective obtained? What we agreed on what the objective was it obtained? And that's not necessarily a yes or no answer. There might be degrees in there. The customer may say, I want to, this case is worth $100,000 to me. If we can resolve it at less than $100,000, that's effective. Well, okay, so you resolved it for $90,000. So that's, is that a zero-sum game? Or did you get 90% effectiveness there? That's the discussion that you can have. But that's the effectiveness side. Efficiency. That's talking about, and Kyle, you put your finger on it a few minutes ago, it's the resources that we thought were going to be used and what were used. So If we are in a fixed fee situation, then that shift really goes over to the law firm side more so than the customer side. I mean, the customer, we've agreed on what the price is, as long as there's not a change order in there. We pay what it is we agreed we paid. But we also really don't want our providers to be upside down all the time. I mean, if they, because it's a relationship. So part of the issue here, part of the trick here is it's really what was the budget, and then what was the actual experience. If you're billing time to the customer, or if you're billing a variable expense to the customer, then it's okay. We said the budget was $1 million, and we got it done for 800,000. That's a 20% more efficient outcome. If it costs 1.2 million, that's a 20% overrun. Now, again, is it a zero-sum game? Is it like a contingency where you get all or nothing? I don't think that's particularly fair to both sides of the equation. Then so you have a way to allocate that. The third E is experience. Lawyers love to talk about experience. They love to talk about how many times they've handled something. They love to talk about the fact that they were a Supreme Court clerk, or they worked at this firm or that firm. I am not talking about that kind of experience at all. The experience I'm talking about is customer experience. What was your customer's experience with you as a provider? Now, people will tell you that's subjective, it can't be measured. That's nonsense. It, of course, can be measured. We measure it every day in our other relationships. Every time we get a survey from Amazon or someplace else, we go to a restaurant, we give them a 5-star rating or not. And so these things, of course, they can be measured, but you have to have a baseline. You have to have a discussion with the customer and the provider saying, this is the way we deal with our customers. Is that okay with you? Is that going to be sufficient? Do you want something else? Do you want to call every day? Do you want memos? Do you want emails? Do you want to go to our website? Do you want information pushed? Do you want access to it on your own when you want it? Whatever that may be, that's all part of that experience. So DB equals E3. So what we did, and I really apologize to you guys, because I think this happened to me before where we tried to do this, Kyle. I've got the live spreadsheets where we can run through examples of this, but I can't give them to you right now.
Why don't you go and show me how you operated it with, go to the, the ACES. Tell us what ACES is. I know. Okay. So report card, ACES, and then the litigation model. Yeah. Yep.
Okay. So ACES stands for the Alliance Counsel Engagement System, which is something back when I was a GC of FMC Technologies we deployed. It's in the public sector. It's readily available. Anybody can use it. I know firms like Littler actually do use it in some of their engagements, and a few other folks do it. Basically, it is a report card. Basically, it is saying, look, we agreed on how we were going to do this engagement. Fixed fee, hourly, some mix. So basically the way ACES works is it says, and this is the simple version, what we used to call ACES LT for ACES Lite. Basically, it just says, you bill us, we pay you 80 cents on the dollar, we hold back 20 cents. We periodically give you a report card. That report card today, it's based on 3 factors. The 3 E's that I talk about: efficiency, effectiveness, and experience. And the scoring, you can see that over on the right side, is a pretty simple scoring system. It ranges from 1 to 5. Now, this is where this particular system differs from some evaluation systems. I mean, like Uber. If you give your Uber driver less than a 5, they get pretty upset with you, because if you give somebody less than 5 stars on Amazon, they get pretty upset. Well, most evaluation systems result in what's been called the Lake Wobegon effect, where everybody is above normal, of average. The reality is everybody's average, okay? And so instead of using words like exceptional or poor or outstanding, we decided to use words like requirements. It's did you meet the objective? Okay, so the objective is a number or an outcome of some sort. Did you meet it or not? If you met it right on, you'd get a 3, met requirements. If you missed it by 20% up or down, that would be a 1 or a 2 or a 4 or a 5. Okay, so it's saying, did you meet or exceed requirements? And you do that on all 3 of the criteria, on effectiveness, on efficiency. What did we say it was going to cost? What did it actually cost? And on experience. What did we say our service level expectations were? What did we agree that they were? What was our actual experience? And so this is a feedback mechanism between the customer and the provider to let them know how they're doing. Now, based upon that score, you get paid the holdback. And the holdback, remember the holdback was 20%. Doesn't have to be 20%, it could be something else, but it was 20%. If you met requirements, you got back the full 20%. If you did not meet requirements, if it was a 1, you lost the entire holdback. If you wildly exceeded the requirements, you got 2 times the bucket. So the numbers here don't matter. Why did I choose 20%? Well, it's because 20% is a substantial portion of a law firm's traditional profit on a matter. If most firms still run by the third model, third for personnel, third for overhead, third for profitability. 20% of the billed amount is significant to the law firm, significant to the provider. And the ability to double that, whatever that holdback is, the money is not as important as the discussion and the agreement. And Kyle, it goes directly to your point about having skin in the game. You could make that number 50%, you could make it 10%. It doesn't really matter. The criteria here is there's skin in the game. Now, why is it important to use a 3 here? Okay, so one of the things that you might not realize if you're thinking about this as an outside provider is, as an inside counsel, I have a budget. I have an annual budget, and that budget is made up of all the matters and all the costs that we have. If I gave everybody a 5 on everything they did, that would mean I was 20% over budget across the board. That would be a career limiting move for me. So one way to moderate that is to basically structure a system that it encourages meeting requirements. I mean, of course you want people to exceed their requirements, but you only pay them if they actually exceed the requirements. And as the in-house counsel, if you're paying somebody more than 100% of what you agree, you either got to find that money somewhere, either by reducing expenses someplace else, or by giving somebody else a lower evaluation. So that's it's a self-correcting mechanism. Does that make sense to you, Kyle?
Yeah, it does. And let me say, we had a question that I'll throw into this question. That is, was the ACES system, did you use it periodically throughout the litigation, or was it the conclusion of the litigation? That's the question.
Yeah,
and then
great question.
Before that, let me say this and comment about something. One of the pillars that we have in our program is this idea of doing the right way. And one of the important ingredients of under the right way is the communication between lawyer and client, and that communication is paramount. Well, what this system that you have here for delivering value using the E3, effectiveness, efficiency, and experience, it enhances the need for good communication between the client and the outside counsel. It's just not, I'm outside counsel, I'm in control of things. No, it doesn't work that way. There's got to be this collaborative effort that between in-house and outside. And the second thing that I would comment about this particular program, Jeff, that I've always appreciated is the emphasis on effectiveness and efficiency is contrary to what traditionally law firms have done.
Right.
You know, you're measured on how many hours that you build your bonuses are measured on how many hours that you bill. Well, here, the bonus and the potential to get the bonus from the client is on efficiency, which is
Right.
not hours billed. It's doing things effectively and efficiently, which I think makes it monumental, right?
Well, I absolutely agree with you, Kyle. It was very effective for us. What I used to tell our firms is I don't want to pay you less money. I'm not asking for a 20% discount. I actually want to pay you more money, but I want to base that on effectiveness and efficiency and experience. Right. At the end of the day, we both win, because if you are more effective, efficient, and give me a better customer experience, my overall expense will go down, and it will free up your inventory, your hours, if you will, to sell to other people. And so it's a win-win.
Yeah. So go ahead and answer that question about when you did it. So
yeah, for litigation, and so this model, the LT model, works for anything. You can use it for litigation, you can use it for contract review, you can use it for HR work. Works for absolutely every kind of engagement. There's a more complex model called it's just ACES Prime or ACES. It was the one we first developed. It was litigation specific, and it looks more complicated, but it's just math. But it basically, there's a spreadsheet, and I'll circulate these spreadsheets for you folks, and you can play with them. Basically, it takes litigation, recognizes, or any dispute recognizes that it's time-based and their phases. Most cases get worse as opposed to better. And then you have a budget for each phase. The customer wants to get it resolved, but also wants to get it resolved more quickly. So I'm willing as a customer to pay you a higher premium on the holdback earlier in the process. So the way we did that was in phase one, which was the first 90 days. And we had a fixed budget for that. In our case, it was $15,000 or $20,000. If you got the case resolved in that first 90 days for us, then you didn't have a whole lot of money in the holdback, obviously, but you got a really big payback on that. And then after that, at 90 days, we have a full case budget. We have a full evaluation of the case, a money standpoint. And now what we're saying is, okay, I don't want to micromanage your work. If in phase two, you think you need to file that summary judgment motion, but you're already pushing up to the target budget for that phase, I want you to still do that work. But I don't really want to pay for it unless it's going to be effective. So what we do is in each one of those buckets of time, we pay 80 cents on the dollar until you go over the budget for that time period. Then we pay 20 cents on the dollar. So now what happens is, if you really think it's going to resolve the case, it's worth it, because you're increasing your bucket. And then the payoff, the multiplier, is higher in phase two than it is in phase three, than it is in phase four or phase five. So what it's doing is it's saying, I want you to do what you think needs to be done to materially contribute to success. I've hired you for your expertise and for your judgment. I'm not a trial lawyer, at least not for a long, long time. And so I'm not going to substitute my judgment for yours, but I want to align our interests. And so that's what the more complicated spreadsheet does. The interesting thing about it is you can play with it. You can put in the variables are really the expected value. What was the decision tree value of the case? The budget for each one of those phases. You fill those numbers out, and then you just put in what the actuals were, and it spits out for you what your financial results were going to be. Now, it sounds complicated. It's just math. There's a simple little tool it just looks complicated. It's actually pretty simple.
Yeah, and it's also putting some skin in the game. So from my perspective, and I think that's something. And the risk reward is great. I mean, plaintiffs' lawyers have been doing it for years, right? I mean, and at some point in time, you got to start thinking along those lines. Right.
And as a customer, I'm happy to do it. I mean, because I'm getting better results, better service, And most importantly is I'm deepening the relationship with my outside counsel.
Right.
They're understanding us more. They're understanding what we expect in terms of service level expectations, how we like to work. And that makes them better providers. That makes the relationship stickier, and it means I'm not going someplace else.
Gotcha. Jeff, I want to tell you, I'm going to thank you. I know you, I'm going to give you 20 seconds or so just to say, what is hot wash in 20 seconds? I know we promised everybody an hour. And let me just say this before you answer that, and before I say final goodbyes, we've put into the chat feature the CLE number for this particular course and the course name, and you're welcome to put that down for attending this particular webinar. So what is hot wash?
So hot wash is the perfection stage of P3, and that's lessons learned, or after action assessment. In litigation, you want to say, okay, this was not a great, we might have won, but we really didn't want to be here in the first place. So what did we do well? What do we want to continue to do? And then what were the facts and circumstances that put us here? Because we actually don't want to repeat that. So that's
come back.
So and that's a very detailed, longer process. You use everybody on the team. A hot wash is a fast track after action, something that I used to use at the end of every presentation, at the end of every meeting, and I encourage you all to use this. And it's just to take 5 minutes at the end of the meeting to say, hey, how did this meeting go? How did this presentation go? What went well, W3? What are the things to take a look at? Not problem solving, we're just identifying what went well, and that's giving feedback. So, I would ask you also, if we run out of time, I'd ask you all to send comments, and Kyle, if you could send them on to me so that I can do a better job next time in doing something like this.
Well, Jeff, I want to tell you something. I appreciate the internet issue, but I thought, quite frankly, it went very well considering that we were using the cellular device. And I can't thank you enough, not just for doing this webinar, but also for your help with our program. And we greatly appreciate you. And I can't thank you enough for doing this webinar for us. And don't be surprised if we reach out again into the future, as I would say.
It's always a pleasure, Kyle. The only thing I didn't like was the inability to actually interact with everybody that was in the room. It's so much richer when you can actually.
It's so much richer because Jeff has been to our campus and he's had to interact with our candidates, and it's always entertaining with those people who are going through our program, isn't it? So it's good.
And I just saw pop up, my friend Aaron Munster is in the group, in the house.
Yes, very true.
And it's good to see him again here. And so happy to help any way I can.
I appreciate it. Thank you, Jeff. Thank you. Goodbye, everybody. Remember, check out the course number for your CLE credit. Thank you all much, and we'll see you next month. Thank you.
Thanks, folks.